What they don't tell you about backing out of a real estate contract is that in North Carolina, you actually have more protection than most other states, but only if you understand the due diligence system. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and I'm here to tell you exactly what you need to know about legally backing out of a real estate contract. In this video, I'm going to break down exactly when you can back out of a real estate purchase contract so that you can protect yourself and your earnest money. If you're buying property in North Carolina, this video is for you. And if you want more information on real estate law and transactions, hit the subscribe button. Now, let's dive in. Section 1, North Carolina's due diligence advantage. Here's what most people don't understand about North Carolina real estate contracts. We're what's called a due diligence state. This means you have built-in protection that buyers in other states don't get. The reason this matters is because during your due diligence period, you can back out for any reason, and I mean any reason. Let me break this down for you. When you make an offer in North Carolina, you're going to pay two things: your earnest money deposit, which goes into escrow, and your due diligence fee, which goes directly to the seller. The due diligence fee is your insurance policy. You pay it up front, and in exchange, you get the right to terminate the contract for any reason during the due diligence period. So for you, this means if you change your mind, find problems with the house, or even just get cold feet, you can walk away. You'll lose your due diligence fee, but you get your earnest money back. Section 2, when you can back out, the complete list. Let me give you the exact situations where you can legally back out of a real estate contract in North Carolina. First, during the due diligence period for any reason. This is your golden window. I see this all the time in my practice. Buyers who discover foundation issues, financing problems, or just decide the house isn't right for them. Second, if the seller fails to provide required disclosures on time. North Carolina law requires property disclosures and mineral rights disclosures, and if these aren't delivered when they should be, you get rescission rights. Third, FHA and VA appraisal protections. But here's the thing most people don't realize. This only applies if you attach the FHA or VA addendum to your contract, and without that addendum, you don't have this protection. Fourth, if the seller breaches the contract. This could be refusing to make agreed upon repairs or failing to deliver clear title. Fifth, if title cannot be conveyed as promised. Sometimes there are liens or title issues that just can't be resolved. Section 3, the money breakdown, what you keep versus what you lose. This is where people get confused about what money they'll get back. Let me explain this simply. If you terminate during the due diligence period, here's exactly what happens. You get your earnest money deposit back in full, but the seller keeps your due diligence fee. That due diligence fee was the price you paid for the right to back out. But here's where it gets interesting. If you try to back out after the due diligence period ends without a valid legal reason, the seller gets to keep both your earnest money and your due diligence fee. Now, if the seller breaches the contract, you get everything back: your earnest money, your due diligence fee, plus you may be entitled to additional damages or costs. The key takeaway is this: timing matters. The due diligence period is your safe zone. Section 4, what sellers can and can't do. Now, here's what most people don't realize about sellers' rights. Sellers have very limited ways to back out of a contract in North Carolina. They can't just change their mind because they got a better offer or decided they don't want to sell anymore. Sellers can back out if the buyer fails to deliver the due diligence fee or earnest money on time, or if the buyer materially breaches the contract. In my practice, I see sellers try to get out of contracts all the time, but unless the buyer actually failed to perform, they're stuck. The bottom line is sellers have much fewer options than buyers. Section 5, critical deadlines and forms. Here's something that trips people up. If you want to terminate during due diligence, you need to use the right form. You should use the appropriate legal form to officially terminate. Don't just send a text or email. Use the proper legal form and make sure it's delivered before your due diligence period expires. Deadlines are critical. I've seen buyers lose their earnest money because they were one day late with their termination notice. Don't let that be you. If your deposits are late, the seller can demand certified funds. So for you, this means get your money in on time and use the proper forms. So let's recap what we covered. First, North Carolina's due diligence system gives you the right to back out for any reason during the due diligence period. Second, you'll get your earnest money back, but lose your due diligence fee if you terminate during due diligence. Third, after due diligence ends, your options are much more limited. Fourth, sellers have very few ways to back out compared to buyers. The bottom line is this: if you are buying in North Carolina, understand your due diligence rights and use them wisely. If you stay within the due diligence period and follow the proper procedures, you can protect yourself and your earnest money. If you found this helpful and you want more information on real estate law and transactions in North Carolina, make sure you subscribe to our channel. And if you're buying or selling property in the Lake Norman area, you can find us at thomasandweber.com. I'll see you in the next video.